A severance agreement can significantly impact your finances, career opportunities, and legal rights. Let's walk through what these agreements typically include, your rights as an employee, and the steps you should take before signing. What is a severance agreement? A severance agreement is a legally binding contract between an employer and an employee that outlines the terms of separation. It often includes a payment, called severance pay, in exchange for certain commitments from the employee. These agreements can also include conditions such as a release of legal claims, confidentiality or non-disclosure clauses, non-disparagement terms, non-compete or non-solicitation clauses, agreement not to sue the employer. While some companies offer severance voluntarily, others provide it only after negotiations or when required by an employment contract or company policy. The most important thing to understand is that by signing a severance agreement, you are usually giving up your right to sue. This could include claims related to the following: discrimination or harassment, retaliation or wrongful termination, wage and hour violations, unpaid bonuses or commissions. In exchange, your employer offers severance pay, which might be a lump sum or a series of payments depending on the agreement. These are the key clauses to watch. Before signing anything, here are a few clauses you should read very carefully. 1. General release of claims. This is often the core of the agreement. It means you're waiving your right to bring any legal action, sometimes even those you don't know about yet. This is a serious commitment and shouldn't be taken lightly. 2. Confidentiality and non-disclosure. These clauses may prevent you from speaking publicly or privately about the terms of your severance, the reasons for your termination, or details about the company. Violating these terms can have legal consequences. 3. Non-disparagement. You may be asked not to make any negative statements about your former employer. In some cases, this is mutual, but not always. So check whether your employer is also bound to remain silent. 4. Restrictive covenants. Clauses like non-compete or non-solicitation agreements may limit your ability to work for a competitor or contact former clients or colleagues. These can have a serious impact on your career, especially in specialized industries. Do you have to sign? No. You are not legally required to sign a severance agreement. Even if your employer presents it as a standard procedure, you have the right to ask questions, request changes, take time to review it. Consult with an attorney. Most agreements include a window of time, often 21 days or more, for you to consider the offer. And once signed, you may have a 7-day window to revoke it, especially if the agreement involves age-related termination under federal law. Don't let pressure or fear push you into signing something you don't fully understand. Should you negotiate? In many cases, yes. Severance agreements are not always take it or leave it. You may be able to negotiate for the following: more severance pay, continuation of health benefits, a positive reference or neutral language in HR files, a modification to restrictive clauses, coverage for outplacement services or career coaching. An experienced employment attorney can help you assess the value of your potential claims and use that information to negotiate better terms. Severance agreements are not just paperwork. They're legal contracts with real consequences. They can offer financial support and a clean break, or they can limit your future options and silence your legal rights. Take your time, read the fine print, and most importantly, get legal advice before you sign. If you've been presented with a severance agreement and want to understand your rights or negotiate stronger terms, visit employeelawgroup.com. We're here to help you protect your professional future and make informed decisions. You don't have to go through this alone. Let's talk.